All right, it's lesson 2.2. Today we're going to answer the question, how do Canada's justice system and the Youth Criminal Justice Act, the YCJA, attempt to treat young offenders fairly and equitably? We got that word again, equitably. We talked about equality and equity in the last lesson. We are going to see it again here today. We're going to talk about youth sentencing, adult sentencing, the Criminal Code of Canada, and we're going to be taking a really close look at the YCJA, the Youth Criminal Justice Act. So stick around and let's learn something. All right, welcome back. It is lesson 2.2, how do Canada's justice system and the Youth Criminal Justice Act, the YCJA, attempt to treat young offenders fairly and equitably. Here we have that word again, equitable. You should know what it is from our first lesson. If you don't know what it is, go back to lesson 2.1. It's a really short lesson. Go back and check out what equitable means. So let's get started on here. I want to do a little quick opening activity with you. I want you to make a list. I want you to make a table, a T-chart if you want in your notebook right now. And from the list below, I want you to place the crimes that you see that you believe can be justified, so able to be shown to be right or reasonable, something that is defensible, or something that is forgiven. So that's going to go into one column. And then in the other column, I want you to list the crimes that are listed here that you believe are inexcusable, that are too bad to be justified, too bad to be tolerated. So from your list, you've got murder. You've got first-degree murder. This is your premeditated, planned murder. You have your second-degree murder. This is not planned, but it is intentional. Then you have got manslaughter. It's not intentional, but it's still your fault. And yes, thank you. I know I have to make changes on these slides here. Then we've got drunk driving, distracted driving, stealing, doing drugs and or selling drugs, hacking, and even kidnapping. So pause the video right now, make a T-chart that you've got as justifiable on one side and inexcusable on the other. All right, I did this activity in class and we came up with this table. 100% wrong, completely inexcusable. We've got murder, stealing, drunk driving, selling drugs, and kidnapping. For 99.99% wrong, so students were able to justify reasons for doing this. We've got hacking, distracted driving, and doing drugs. Okay, don't at me, don't send me emails that I'm wrong or this is wrong. This is what we came up in our class discussion. So I'm going to pose a question to you. What if you kill someone who is attacking and trying to kill you? Well, this is self-defense. Is that justifiable? What about stealing a loaf of bread and some apples? Your family is starving. You need to feed them. Is that justifiable? How is that different from, let's say, stealing a TV from Best Buy? I'll give you a minute right now. Maybe change some of your options and your answers here for your inexcusable and for your justifiable sections. Okay, we're back. You probably made some changes. Well, when I did this with my students, we've made some changes too. And they still agreed that for 100% wrong, inexcusable actions, we've got first-degree murder, second-degree murder, stealing if it's for fun, drunk driving, selling drugs, they stipulated for minors, and we've got kidnapping. Still wrong, 99.99% wrong, but able to be justified, they came up with murder, so self-defense and manslaughter, stealing for survival, they put hacking in there, they put distracted driving in there, and they put doing drugs in there. The whole distracted driving came from a conversation we had that if you're in a lineup in a drive-through, well, you can't be on your device because that's considered distracted driving. So they were arguing, yeah, but we're stopped, we're in the drive-through, and we can justify doing that. You can see here that there's no real right or wrong answers, and there's always going to be what-if situations. And this is where discretion plays a huge role in determining the guilt of each crime that is committed. What this means is that each case needs to be reviewed on its own, and all facts need to be considered before making a decision about whether somebody is guilty or not guilty, and for what punishment is going to be laid down on the individual. We know, this is nothing new, we know that minors are not as mature as adults. Adults are just more mature. We know that. So why should someone who commits a crime when they are under 18 be treated differently than an adult? What about 13 or 17? Do you see where things can get a little bit murky, right? Definitely things can get a little bit murky. I've got a cartoon here. We've got Lady Justice, and we went through who Lady Justice is back in the first lesson 2.1. So this is our political cartoon here. We've got Blind Justice. This is Lady Justice. She's wearing her blindfold. But she has a seeing eye dog. And on the leash or whatever of this seeing eye dog, we have something called racial bias. And in the next lesson, in 2.3, I'm going to take a look and I'm going to show you some figures about the racial bias that exists in Canada's justice system. But let's go back and take a look at some history. We're going to take a look at how Canada approached youth crime since the 1900s. Well, in 1908, the Juvenile Delinquent Act came into play, and this recognized that youth should not be treated like adults. Youth are completely different. They are not adults. In 1984, the law changed to the Young Offenders Act, the YOA. Under this act, all youth cases went to court. And the problem there was that there was long wait times and there was inefficient sentencing. So the sentences that were given were either way too late, way after the crime was committed, or the sentence didn't mean anything to the offender. And it relied on the assumption that young offenders are hedonistic and responsible for their own actions. Fast forward a few years, and it takes us to 2003, where the current YCJA, the Youth Criminal Justice Act, was introduced as a federal law and applies to every youth between the ages of 12 to 17. In other words, 18 years old, less a day. Think about that for a second. There are some key goals that the YCJA has. Number one, first bullet, all youth must be held accountable for their actions. Number two, rehabilitate youth by instilling positive behaviors and attitudes so they may reintegrate into society again. Number three, consequences determined for each case in a timely manner. You commit a crime in grade 9, you shouldn't be sentenced in grade 12. You need it done in a timely manner. Number four, the public must be protected from serious offenders and victims should receive justice. And the fifth goal is the prevention of repeat offenders. And all of this is grounded in the idea that youth are responsible for their own actions. Generally, the YCJA judges easier on the lesser crimes that exist because we want to try and keep youth out of the justice system completely. Well, why is that? Well, there's two theories. The first one is our labeling theory. If you are constantly labeled as an individual, bad individual, as a criminal, as somebody who acts out, well, then you are going to act like that, right? So if you're labeled as person X, you are going to act like person X. And then the differential association theory, this is your ties to the connections that you have. This says that committing crimes is a learned behavior. It comes from deviant peers, and you learn how to do this from other people. And the research shows, this is from 2011, research shows that the certainty of punishment is more important than the severity of the punishment. Long sentences, these are hard to justify because they have little to no effect on deterring future criminality. This is from some research that was done in 2011. All right, you've heard these in movies before. You've seen these on TV shows. You've got some legal rights, my friends. You do have some legal rights. So if a youth is arrested, here are the rights that they have. And some of you you've seen enough TV shows that you can name off these rights fairly easy. You have the right to know why you are being arrested. You have the right to remain silent. You have the right to talk to a parent or a trusted adult. I am included. You could call me as your teacher. You could call me. I'm a trusted adult. You have the right to be represented by a lawyer as soon as possible. And you have the right to have a parent or a guardian be present if you want to make a statement to the police. Those are your rights as a youth in the justice system. Now, the Youth Criminal Justice Act is different from the Criminal Code of Canada. The Criminal Code of Canada is only applied to adult offenders. It means going to court is the usual consequence. It defines all adult sentences, usually prison. It allows for the publication of names, and it creates a criminal record for most offenses that occur. The Youth Criminal Justice Act, on the other hand, deals with your 12 to 17-year-olds, so your 18 less a day year olds. It allows for counseling or community service as opposed to going to prison. It prohibits adult sentences for those between the ages of 12 and 14, but it does allow for adult sentences between the ages of 14 and 17 if the crime is serious enough. It protects the privacy, so you can't publish the names of young offenders, and it allows for people to avoid committing or to avoid receiving a criminal record. Whoa, look at this thing. This is quite the flow chart. This is right out of our textbook, and we will go through this flow chart here. We are the young person. I'm going to use my mouse. I don't typically use my mouse in my videos because I don't want to distract anybody, but this is not an easy thing to follow. We've got the young person. The young person decides right here to break the law, and that person is going to deal with a police officer. That police officer has a choice. We can either charge the young person or don't charge the young person. If the police officer decides not to charge the young person, well, a warning will be given. So you could be given a letter sent to the youth's family, to the youth's parents. Or the police officer can choose to refer the young person to a program for help. That could include social workers and mental health workers or community volunteers, where the young person will go and complete a program. If the program is completed, the young person is then considered to have completed the program and goes on with their life. The other option a police officer has, let's head back over here, is to charge the young person. If charges are laid, depending on the severity of the crime, if the crime is serious enough, that young person will then go to court. If it's not serious enough, it will then be sent to a prosecutor who is a lawyer who uses evidence to show that someone has broken the law. The prosecutor can then decide, hey, we are going to go to court, or the prosecutor can go and seek the assistance of mental health workers, social workers, community volunteers, and things like that. And the young person completes a program. And if the program is completed, then the program is completed. If the program is not completed, the person goes back to court where they go to a judge, and the judge will determine, hey, maybe we should go back to the social workers, mental health workers, or community volunteers, or the judge might deem that a sentence, a more harsh sentence, is necessary. So we'll send the young person over here. And over there, we'll have some community services, some counseling, maybe prison, maybe a criminal record, some restitution perhaps, so we're paying back for property damage and things like that. So there's a lot of options here once a young person, or if a young person commits a crime. But we want to keep youth out of jail. So some ways that we do that are with extrajudicial measures. So a police officer, for example, can take no further action than just issue a warning or a police caution, or maybe even referral to a program. Or the Crown, the courts, can give a Crown caution. This is the least of the measures. Then we've got extrajudicial sanctions. This is different from extrajudicial measures. The sanctions are contracted punishments ordered by the court, so your Crown prosecutor, who will determine the appropriate punishment. For this to take place, you must, number one, admit to having committed a crime, and number two, be willing to participate in the program. During these extrajudicial sanctions, you must follow specific rules, you must follow specific conditions, your behavior is monitored by a probation officer, all kinds of things need to take place. I got a whole list of things here that would qualify as extrajudicial sanctions, all the way from issuing a formal apology to the victim, to writing an essay or a poster, to participating in a victim reconciliation program, making a donation to a charity. All kinds of extrajudicial sanctions exist. You can go up and down this list as you please. And then another way that we try and keep youth out of jail is by having police referrals. So this could be like making contact with child welfare, This could be your youth justice committees. This could be your recreational program. So maybe what you need is, maybe you're getting in trouble because you got too much time on your hands. You're bored and now you're doing bad things. So you go and maybe you are joining a sports league or whatnot. A referral could be towards an alcohol or drug treatment program, a counseling agency, a mental health program. Basically, the goal here of these police referrals is we want to keep young people out of the court system. Unfortunately, that doesn't always tend to happen. Sometimes we do need to lay charges, which means a court appearance needs to take place. In court, you enter a plea. You either enter not guilty or you enter guilty. If you plead guilty, you go straight to sentencing. If you plead not guilty, you can either get released pending your trial or you go into a detention center while you await trial. Either one will lead to a trial. And in trial, you are either found not guilty or you are found guilty and then you get sentenced. Now, your sentencing is happening from your judge. And usually a judge will take a couple of things into consideration. What was the seriousness of this offense? How serious was this offense? What's the history of the youth? Okay, maybe they'll go back and they'll go to the schools and they'll maybe subpoena some of the school records to see what type of individual this is. Definitely the attitude of this young person is going to play a huge role in sentencing, and obviously the circumstances that the youth faces in leading up to the crime that was committed. The most common sentences, there's 7 sentences, the 7 most common. Number 1, you'll get a fine. Maybe there'll be some compensation. You'll have to pay for something. Maybe there'll be some restitution. Again, this is long periods of payment. Though it could be community service. Intensive support and supervision orders could take place. Custody and supervision orders, or even probation could happen. So a police officer does have a lot of say in what actions are going to be taken. We could go for extrajudicial measures, we could go for extrajudicial sanctions, or we could have a court appearance. So depending on the severity of the crime, the level of crime, we could go without any charges, no court or no record. Maybe you're going to court and then you'll participate in a program, still trying to avoid that criminal record, or you formally go to court where you are in front of a judge, lawyers, maybe even a jury, and you get a youth criminal record, and maybe, depending on the severity of the crime, you could even be charged as an adult under the Criminal Code of Canada. If you're charged as an adult and you are under the age of 17, so between that 14 and 17, you could receive an adult sentence under the Youth Criminal Justice Act. Because if you're over the age of 14, depending on your the severity of the crime that you've committed, the YCJA may no longer apply to you. But this is only really used when youth punishment is not harsh enough or it's not long enough to hold the youth accountable for their actions. So some examples of where adult sentences will be used: first-degree murder, second-degree murder, manslaughter, aggravated sexual assault, attempted murder, serious violent offenses. These are all examples of where adult sentences could be handed down to youth between the ages of 14 and 17, so 18 less a day. One of the things that the Youth Criminal Justice Act does is it protects the name of youth who've committed a crime. That name cannot be released under the YCJA, except for two exceptions. There's two exceptions to this rule that exists. Number one, the youth is tried and charged as an adult. And number two, that youth could be a threat to the community and there are community lives in danger. In that case, the names will be released. I want to finish off talking about offenses and records. There are two types of offenses, summary and indictable offenses. A summary offense usually results in a fine of under about $2,000 or so and under 6 months in custody. Yes, you will get a record, but that record will last 3 years after the completion of that sentence. Then we have indictable offenses. These are your more serious offenses. You'll have fines over $2,000, and an indictable offense will have over 6 months of custody. And for a youth, that record will last for 5 years after the completion of the sentence. So you're either looking at a 3-year record or you're looking at a 5-year record. And a record is what people are trying to avoid as well, because there's different types of records that are out there, different types of criminal records. You could have local police records. There could be formal court records, your CPIC records, that's your Canadian Police Information Center records. Other organizations have records as well. And this is in the movies where you see they do like the fingerprinting on the scanners, but it's not always done that way. Sometimes it is low tech, right, where you use the ink on the fingers. And this is to be able to identify you. Let's say if you wanted to go for, let's say, employment, for example, having a criminal record will prevent you from certain types of employment. A criminal record will prevent you from traveling. A criminal record is also going to prevent you from immigrating. A criminal record will also stop you from attending certain high-level schools. There's a whole list of things that a criminal record will prevent you from doing. All right, I want you to head over to your notebooks and complete the questions for this part of the chapter.